recorded. All right, now that we have it recorded, share. And going back to the slideshow. All right, so post-closing buyer-seller disputes. Okay, so what do we do when the love is gone, you know, when there's issues? So what today's topic is really just resonates with me in many different factors. One, I've seen situations, occurrences, and problems happen after the deal closes. Nothing goes wrong until the deal closes, the buyer moves in, and now all these problems happen. How do you handle those circumstances? Because guess what? Who do you think they're going to be calling? They're going to be calling you. If you represent the buyer, in this instance, they're going to be calling you and saying, Simon, I have a problem. I moved in yesterday or over the weekend, and now we have these issues. Plumbing issues, sewer issues, electrical issues. And a lot of those can be minor, and some of them can be a major issue. How do you respond? How do you tackle those conversations? And more so, how do you please everyone for potentially getting bigger than what it is? Okay, so that's what today's topic is going to be, is really just an essential understanding how to approach it and how to avoid a potential pitfall, meaning you being in a triangle of a scenario situation that ultimately puts you in a lawsuit or a complaint. Okay, we never want to be that. We are the neutral party on this instance. For example, once the deal closes, ladies and gentlemen, the deal closes, your hands are free. You have no obligation whatsoever to be entangled in that mess, okay? Because you are completed that transaction. You got paid for that service already of closing the deal. And it doesn't matter who you represent, the buyer or the seller. But in this particular situation, we have those relationships with people, right? And we don't just walk away or avoid any calls that are coming in. We take the proactive approach, right? We roll up our sleeves, we tackle on the responsibility to see what can we do as an agent to solve that problem. As I mentioned, it can be something small, it could be something major. How do you tackle, how do you navigate that process? Okay. Some helpful to help identify the problem, don't diagnose it. Ask questions. When was the issue discovered? What has been done about it? What is the cost for the fix or remedy or cure? Has an expert consulted you? Do you have any photos or videos of the situation? Here's the proactive approach, ladies and gentlemen, that you need to ask a lot of questions. Now, you also should be documenting all this, okay? Because let's say you represent the buyer, you go through the motions through escrow, it's a 30-day escrow. Congratulations, Mr. and Mrs. Buyer, here are the keys to your beautiful home. And then that's when the chaos and the problem starts happening, is after the deal closes. I'll give you a scenario that happened to one of our agents here at the office. He represented the buyer, and as soon as the deal recorded, the following day, the sewer busted. And now the sewer and the backflow was going into the house, in the shower tub, and also in the sink. Somehow, some way, it came back. And now we were looking at an $8,000 problem, because now the entire sewer line had to be replaced. Who's responsible for those type of situations? The deal just closed, and now the sewer line busted. What a coincidence. How do you handle those conversations? Who is to blame? Who is responsible once the deal closes and exchange of ownership happens? That's a very good question. My goal today is to help you navigate those conversations, to give you a good perspective in how to deal with it, because it's never easy as an agent. Oh my gosh, what am I going to do? How do I handle the conversation? I don't want to say something that will stir me to be involved in a potential claim? So that's what today's topic is going to be. Ask a lot of questions and make sure that you document it as well. Okay, as to who, what, and where it happened. Videotape, photos, all that is compelling because that really paints the story, paints the picture, and also it gives you a good ammunition if you have to get the other agent involved and probably the company as well. So looking at it from all different angles, all different perspectives to really achieve the goal. Because what do you want to achieve here? You want to make sure that the buyer is happy. No one wants to buy a property and now get all these problems, all these issues with their homes, right? You want it to at least last 6 months or at least a year before the problems happen, right? Not instantly after the deal closes. But does it happen? Yes, yes, it does. So having those conversations and diagnosing the problem to make it a win-win all around. Okay. And as we go through the presentation, folks, if you have any general questions, please let me know as well. I'll be more than happy to answer any of your questions as well. All right, potential solutions. Okay, have you reached out to the home warranty? Did the buyer get a home warranty? That's the first thing I would be saying is I would be going and pulling out that file. If you don't have the file, talk to your TC, talk to the company. Hey, I need the file on 123 ABC Street here in the city of Torrance. I need to see the file because that paints the picture, right? That tells you the story of what compel you to be where you're at. Maybe it was already embedded in one of the disclosures. And unfortunately, the buyer's agent and the buyer missed it. And it was clear as light that it was there and we didn't see it. And that can happen. But that'll also put the scenario, the situation at ease, because now you can say, well, based on what I see here, the seller did disclose this situation early on when we proceed. And unfortunately, because of that, you had the right to get additional inspections. And then we'll dive a little bit more. I don't want to jump too ahead of the game, but I want you to also keep that in mind. How do you handle those conversations? Looking at the home inspection as well, the general inspection, okay, going back to the file. What was transpired? What does the report show? Was there already potential risk regarding a certain item, electrical, plumbing, roof, whatever the case may be? Maybe the report will show it and we can circle back to that as well. That could have been something that we requested as part of the request of repairs. Now, one thing that I need you to please understand, everyone that's on the call right now, is that all property are sold in its as-is condition, meaning that the property is sold as is. Seller does not have to do any type of request of repairs, credit, or even a price reduction. Seller doesn't have to do anything. They can be silent throughout the entire process. And guess what? You have to make that decision, meaning you as the buyer would have to make the decision to continue with the process or decide, you know what, maybe this just has too many risks. I don't want to take on that responsibility. I'd rather cancel and move on to another property. And that's okay as well. Any direction is perfectly fine because the direction is based on the buyer, not the agent. Remember, you do not want to entangle yourself in any situation that they bring you into it. You buyer agent, you listing agent told me so, okay? Because once that is said, it's game over. Now they're going to entangle you in this chaos and mess, and any savvy attorney will try to dissect that and also try to get you involved in paying some of the damages. So be very, very, very careful. Repair person during escrow. Maybe you had someone go and give you an estimate, and then that estimate was an avenue of potential risk that was eventually going to give in, and it gave in. But at least it'll paint the story. Title companies, again, I don't know why title company is on here, but even researching encroachments. Okay, those are very, very popular situations that may occur. You thought you were buying this lot that was 6,000 square feet, but because the buyer didn't do their due diligence, we didn't know that a percentage of the encroachment from the back homeowner or the side owner is encroaching into your property. And we failed to investigate or failed to notice that. And now you have a dilemma in a situation. And again, that may be something that you can find on title.
Can I ask a question?
Absolutely.
What about the encroachment is to the utility company?
Okay.
What you still have to disclose, but does it affect the size of the lot?
Well, it doesn't affect the size of the lot because an encroachment can also be a telephone pole, right? It
Right.
could be one of those signs. It may be one of those cellular towers too. I've seen where there's properties that have cell towers, and
Right.
it's in your property. Now, all that is going to be disclosed, part of the disclosure from the seller. If the seller is getting any type of compensation regarding cell towers, stuff that they were getting some type of residual income from it, it has to be disclosed and provided to the buyer.
Can you actually get residual from the public utility company?
It depends on the circumstances. No, for the most
Okay.
part, no. Those are for the benefit of the consumer. So therefore, if they're encroaching in your property, a telephone pole, cable company, those are not considered encroachments that are for compensations. Where you'll see compensation is like cell towers. Where you see compensation is like billboard campaign, like the billboards that
Right.
they put in there and they get compensation. So then yes, they can also include some type of percentage of compensation to the homeowner as well. Okay.
Thank you.
Good questions. Thank you, Farah. Read instruction manuals. Absolutely. Make sure that anything that the seller has provided you with, all the manuals, to have the buyer research. Have you looked at the manual that was provided to find out maybe it's a very simple fix, that what it looks like may be something that is not that big. It may be a minor situation that can be completely done by the buyer. And then lastly is ask the other party. Being proactive, being engaged in those conversations, and reaching out to the listing agent. So these are what we call potential solutions. As soon as the buyer says, hey, you know what, we have a problem, don't overreact, meaning stay calm, stay collect, and just listen to what the buyer is saying, because you may also miss something that could have been easily resolved if you would have been a good listener. Don't overreact and don't get too entangled in the emotional aspect, because obviously the buyer will be probably very anxious and frustrated and probably upset. And now the buyer is going to start pointing fingers at people. And the first one to point finger is you as the professional agent. So be very, very cautious and make sure that you document everything. Some of the relative contracts and terms, okay? And this is where it's strictly from the purchase agreement, which is your RPA, that all property is sold in its as-is condition, requires disclosures of any material fact. So here it is, folks. The contract is the contract. The information is on there. All you have to do is, when having these consultations with your buyers and the initial process when you're in escrow, is making sure that the buyer is very aware that Mr. or Mrs. Buyer, all property are sold in its as-is conditions. We can definitely attempt to send out a request of repairs to fix certain items that you feel compelled that should be addressed by the seller. But there's no promise, no guarantee that the seller will come back and say yes to repairing, yes to replacing, or yes to credit, or even a price reduction, because all properties are sold in its as-is condition. And how I've been able to accomplish these conversations is I always switch the hat. Well, what do you mean, Simon, switch the hat? I would put the buyer as a seller. Well, let's put you as a seller, okay? And you were selling your property 5 years from now, 10 years from now. It's going to also impact you as well, that you as a seller will also have the right not to do any of the repairs, replacement, credit, or price reduction because you're selling the property as well, and as is condition as well. Okay, so keep that in mind. The other thing that I need you to also understand when looking and doing your fiduciary responsibility as a professional is making sure that you're also acknowledging reading these documentation as well. You're the expert. You should understand the dynamics of every document that is provided to your client. Why? Because it's your responsibility to also red flag any potential pitfalls, things that the buyer may not understand or know. Okay. Now, we never practice law, right? We never give any legal advice or taxation advice. We always refer them to those experts. If it's a legal situation that is very sensitive, I'm not a legal expert. I cannot advise you on that. Here are some suggestions, or maybe speak with your attorney. The other avenue is also, any taxation. We're not, as long as you're not licensed to do tax or law, then you shouldn't be having these conversations. Now, the TDS, which is better known as the Transfer Disclosure Statement, and the SPQ, which stands for the Seller Property Questionnaire, are very important components. This is what causes a lot of strain and frustration in lawsuits when there's no material facts about the property. Now, maybe the seller did not know that there was any issues with the property, but if the seller knew and failed to disclose, then you may have a claim. But the claim has to be proven that the seller did not know about this material fact. Now, what are some of the concerns that we see here? What are some of the red flags that you would say, well, there's no way that the seller couldn't have known about this disclosure or issue with the property? If one of the things on the property, well, as soon as you turn on the hot water, there's rattling sound, like something is shaking in the pipes, that's probably something that the seller should be disclosing, because I don't think it would just happen from one day to the other. This is why you need to really have a good home inspector to do those particular checkings, making sure that they test, open up the hot water, open up the cold water, and just listening and hearing to see one, pressure, sounds, okay? And that should be part of the condition. If the seller knows about it, they should be disclosing that. Well, what about a neighbor's dog? What about if the neighbor has a dog that at 4 a.m. starts barking, and it's a consistent bark for hours around that time frame, and that was not disclosed to the buyer? Well, the buyer may have some claim. If the neighbor has lived there for many years, you can argue the fact, well, it never bothered me, and it may bother the buyer. This is the reason that as a listing agent and as a seller, the listing agent should be very proactive in their approach and making sure Mr. and Mrs. Seller, part of the initial process of disclosures and material fact is to provide the buyer with as much details about the condition of the property or anything surrounding the property for the benefit of you and a potential liability in the future. So the seller may be adamant about, disclosing any material facts, but it's, again, peace of mind that down the line that the seller will not get sued, because that may happen because the agent failed to provide adequate information to the seller that is part of the process. I'd rather give an overload on material fact and disclosing stuff then limit that because they're afraid that the buyer will cancel or the buyer will not buy the property. Well, if you weigh it out, ladies and gentlemen, if you really truly weigh this out, is it worth the headache, frustration, time wasted on someone that's going to sue you? Because it's going to put a lot of strain, it's going to put a lot of stress, it's going to take time off, and it ultimately can cause damages where there's monetary issues. Okay, no one wants to be in that circumstances, and that also will impact you as a listing agent as well. So having a proactive approach is necessary, and it's very important to protect you and your clients from any future complaints or even lawsuits. So the SPQ and the TDAs is a prime example that it provides the consumer, the buyer, with additional material facts about the property. I rather go overboard and provide as much about the property and let the buyer make that decision, because here's the big picture. Once the buyer releases that condition or contingency, then basically what is understood by the buyer is that the buyer has read, has acknowledged, and has understood what they have signed off on. And now you can use that to your advantage. Well, we provided this disclosure to the consumer, or the buyer, I should say, and the buyer signed off and acknowledged receipt, approval, and has released that as a condition. So the seller and the listing agent can use that as a pillared or as a structure foundation to say, this is the facts. The facts are the facts. We provided that material fact, buyer acknowledged, buyer sign off on it, and therefore we are not responsible. We're not liable for that. And that's a essential arsenal of tools that can be used against the buyer. So for me and a lot of agents, disclose. Give as much information and let the buyer make that ultimate decision if they want to go forward. Because again, going back to the situation with the dogs, okay? And I'll give you another scenario. Many years ago when I was a kid, I lived in an area that there were farms. And in the area, never failed, the roosters around 4 or 4:30 in the morning, they would start doing their thing, you know? And back then, I didn't know that can be considered a nuisance, okay? Is that something that you think you should disclose? Hey, you know, we hear roosters in the morning around 4 or 5 in the morning. I think that's important to disclose. Well, Simon, that's ridiculous. Why would we disclose about roosters that are not even in the property? Well, what if the new buyer works super early and sleeps and or works late and wants that time to sleep, and they do not want any interruptions throughout their time that they're in bed or asleep? You know, I'd rather be in that position that says, well, the buyer probably would not have bought this property if they have known of that situation. Okay. One situation happened when one of the agents here many years ago. And the agent was listing the property, and the owners own half an acre property. Now the owner had a huge backyard, and then it was adjacent to the hill. So the agent reached out to me at the time and said, hey, I have a question for you, and I'm not sure how to approach this. I don't know if I should have the seller disclose it or not. And I said, okay, well, give me the situation or the scenario that transpired, and then I can give you my personal opinion on it. He says, well, you know, my seller has loves to play golf, and he uses the backyard as a place to hit balls. He has like a range, he has clubs, and he just whacks these golf balls in the back. I said, well, does he pick up those golf balls? No, he leaves them there. There's probably thousands and thousands of golf balls because it was a ravine. The property owner had a flat land, and then it went down the ravine to like a wash. And then his backyard, you can see the hill, which the at the top of the hill was one of the residents, but it was so far out on the top of the hill, there was no way that a golf ball would damage any of the house. But the question here is, what he said to me is, there's probably thousands of golf balls in the backyard. Now, as I mentioned, it's a ravine. You have to go down the ravine and into this wash that ultimately takes you up to the hill. So I said, absolutely. I think you need to disclose that what the seller told you. Okay. And you're saying, well, you want me to have the seller disclose that there is golf balls in the backyard? I said, yes. Okay. As ridiculous as it sounds, I'm looking at it from a different perspective. Okay. What is that perspective? Well, the new buyer moves into the property. The new buyer was never aware of all these golf balls. The new buyer happens to go down the ravine late evening and ultimately steps on one of these golf balls. Maybe he's barefooted. Maybe he loses control of himself. And now he fumbles and stumbles down the ravine, cracks his head, and now he's disabled, or even maybe even death. And the following day, the wife or a family member is trying to find the homeowner, and they finally find the homeowner, and to everyone's surprise, that there was thousands of golf balls where he ended up dying or potentially being disabled. My question to everyone on this call, okay, is that a potential claim against the seller? Because the seller never disclosed there was thousands of golf balls. The seller did mention to the listing agent, but the listing agent just felt, well, it's just golf balls. It's out in the backyard. No one should be going back there anyways. But now there's a situation where, the seller has either been injured or, even possibly death because of the golf balls. Think about it for a bit. Just think about it. And if you really think about it and really see and paint the picture, I can see potential liability. Folks, we're in California. California is known for suing people for some of the most ridiculous things. It only takes someone to file a complaint in motion. And ultimately, what the attorneys want to avoid is going in front of a jury, because in front of a jury, it's a coin toss. You can have a compelling position and really articulate your position of what transpired and disagree that shouldn't have been a material fact and not disclose it. And then the other consumer would have said, well, I have to disagree with you. I think it is considered material fact because, one, the buyer would have been aware of all these thousands of golf balls that were down there, and he would have taken a proactive approach to not, one, go down there during dark to be able to see where he's stepping and probably do something different. And that person may have a compelling position. Here's the problem. If it goes in front of a jury, there's no promise, no guarantee that it can go one or the other way. You may have that compelling argument and everything fits the evidence. The juror may see it in a whole different eye. Remember, you have 12 different personalities, 12 different opinions in how they see it, and there's no guarantee. So guess what? Attorneys do not want to take it to a trial by jury. But when it gets to that level, you're looking at so many costs and expenses, attorney fees, time away from your daily work, time away from your seller or your buyer. So protecting your clients from the very beginning is crucial and very important. because this can avoid future liability, future claim. So I'm just telling you, be proactive, be in the big picture, or see the bigger picture, and really just ask a lot of questions. Because again, no one would have known this, only the seller. And if the seller never said it to the listing agent probably would have not known about this. But the listing agent put two and two together and realized, I see the range. I see that he has buckets and buckets of golf balls. They're going somewhere. He's not going to the range. He's actually let me hit some balls and whack it, 175, 200 yards. So obviously, asking those right questions will lead you to say, okay, Mr. Seller, Mrs. Seller, I think it's important to also disclose that. And again, I'm just giving you a perspective and looking at the bigger picture. Okay.
So sorry, the solution for that is just go remove the balls and, just make it as safe as possible, right?
Yeah, absolutely. The best solution would be, Mr. and Mrs. Seller, I'm helping you avoid a claim if you can pick up all the golf balls that you have been hitting for the last 25 years, because the guy, if I remember correctly, had lived there, was the original owner, has been living there for about 25 years. That's a lot of golf balls, but if they can be proactive, yeah, by all means, go pick up all that stuff and avoid a potential issue down the line. Okay. Again, it could go one way, it can go another way. I'm just giving you ways of thinking, folks. Just a way of thinking is to ask a lot of questions. Okay. And that's where the TDS and the SPQ come in. Both ask if seller is aware of any issues. Okay. It makes the seller think, and sometimes they may even forgotten. Okay. Here's another scenario. I'm going to ask everyone on the call. Okay. And it's a good group of people on this call. What if the seller has pets, right? And they've had dogs, or they've had cats, or they've had birds, who knows, whatever the case may be. But what if they tell you, well, yeah, a lot of my cats and dogs are buried in the backyard, okay? You have a pet cemetery in your client's backyard, okay? Yeah, it may be funny, but does that happen where pets are buried in people's home? Yeah.
I had a client who told me that.
Yeah. So again, I'm just making you think a little bit. What if that came your way? You were going on a listing and you got the listing and you're now providing these disclosures to the seller. Do you think it's important to disclose that as material fact? Hey, I have pet cemetery back there. I've had buried a couple dogs, a couple cats, maybe the ex-wife, who knows? I'm just kidding. I'm kidding. Okay. I'm just saying.
The wife always gets buried. Let's bury the husband this time.
Well, we'll throw the husband back there too as well. Okay. We'll scratch that. It's a joke. Okay. You gotta have a sense of humor, folks. Okay. I hope everyone is laughing. I'm going to throw anyone. It can be husband, it can be wife, it could be anyone. I'm just saying it as a avenue of conversation. But yeah, let's just say that there's pets that are buried. I think it's ideal. I think it's ideal to disclose that, because again, you do not know people's behaviors. You do not know if they're very superstitious. And what if they buy this property and they saw the movie Pet Cemetery and are freaked out? You never know. So I'd rather disclose the mere fact is if the client, your clients, have buried any type of animals, to disclose that. Well, Simon, why would we want to disclose something of that? Well, you never know. What if they start doing landscaping? What if they start doing added square footage to the property? Maybe they want to add a swimming pool. You never know. And then now they're starting to do the work, and then all these little bodies start coming out. That's going to freak people out, And now they probably would have said, you know what? I wouldn't have never bought this property if I knew that this was a burial, because they might be superstitious. You just never know.
So
Now,
how do you remedy something like that?
how do you remedy? Well,
Yeah.
one is ask questions. If you know, and the red flags are immediately, okay, here are some of the red flags. If the consumer has pets and the consumer has lived there for quite a period of time, ask that question, and be front and upfront about it. Mr. and Mrs. Seller, I know you own pets, and I know in some cases people bury their pets in their backyard. Is there any pets that were buried here? That's simple. Oh
But how do
gosh,
you
yeah.
remedy if this happens? How do you fix it?
Say that again.
How do you fix that issue?
Well, you can. What do you mean? How do you fix the issue? You fix
But
the issue by disclosing.
if there are animals, buried there, and you say, okay, I know it's there, but seller says, tell me, how do I remove all those little bones?
No, you don't. You don't have to remove them. Okay, it's a burial. I know as a kid, I remember burying, birds and animals. I didn't know any better. So, my parents still own the property. They've been there for 30 plus years. So I know there's pets there. And if, God forbid, something happens to my parents and I have the decision to sell the property, I probably will disclose that. 30 something years ago, 25 something years ago, there was pets that were buried here. Again, I'd rather be proactive and engage. But to answer your question, you do not have to go in there and start trying to find where these body parts or bones are at anymore. No. That's not what I'm telling you. What I'm saying here, folks, is that, if you know about it, then it's best to disclose it. I'm not saying you got to go back there and remove all that stuff. No, it's done. It's over with, but a buyer may see it in a different light. The buyer may say, well, you know what? I appreciate you telling me. It's like death in the home, right? Do people die at home? Absolutely. My grandma passed away in my uncle's home. If my uncle decided to sell within that 3-year period, guess what he would have to do? He would have to disclose that there was death in the residence. Okay. Again, I just want you to think a little bit and how you approach this from two different perspectives, because again, the whole purpose of today's lecture is just to be cognizant of your role and your responsibility. Understand the pros and cons to this, but being proactive in your approach. This is the whole purpose of the topic today of post-closing seller-buyer disputes, because what you're trying to avoid is a potential pitfall, and now you're dragged into a potential complaint. Now you're summoned to go to court. Now you're involved in a lawsuit that could have been easily avoided. That's it. That's it. All right.
I wanted to ask, what is the statute of limitations? Like, say, the house closes on 30th of January. How long do we have? Not we, like, how long does the client have to dispute or bring a case against either of the agents or the sellers?
Very good question. Okay, very, very good question. Now, there's a reference to that particular question that I'll share with you as we conclude with the presentation. When does the statute of limitation begin and end? So here's what my understanding is. It's at the time that the buyer is aware of it. Okay, it's at the time that the buyer is aware of it. So Simon, what you're saying is if the buyer is not aware of it till 5 years from now, that's when the statute of limitations starts? Unfortunately, my understanding is yeah. And then they have 3 years from that time of them knowing about this to put a claim against the seller. Now, again, looking at the bigger picture, folks, okay? I'm not here to scare any of you, okay? But I'm here to educate you on the pros and cons and having a different angle and view of things. That's it. I want you to be that diligent agent similar to a detective, okay? What does a detective do to solve a scenario or a homicide, right? They ask a lot of questions. So don't be afraid to ask questions, because what are you trying to achieve here? You are trying to achieve a problem down the line. Now, most transactions close with no problems. But if you do a lot of transactions, folks, what's going to happen is there will be a time where something just doesn't go the way it should be. Okay. This is why I'm having this presentation to just give you a different light and a perspective in how to approach those conversations, being that proactive agent. Okay. So going back to the statute of limitation, and I'll share with you some information that you can get to within the California Association of Realtors. Okay, we'll dive into that. You know, when does it start? How does it protect the consumers? And you know, what is the time frame? The time frame. So it's at the time that the buyer is aware of that situation that starts the trigger of a 3-year period to bring suit to the seller. Okay, I hope that answers your question. Relative contracts and terms. Okay, again, yes.
Can I ask another question? Sorry.
Absolutely.
What if an agent is a witness in another listing agent withholding a document that the listing agent never submitted to escrow and never became a part of the transaction, but it was signed, approved by buyers and sellers? It's just listing agent withheld it from everybody.
Well, go a little deeper on that, because give me like a more concise scenario. What is the situation?
The seller had asked wanted a 90-day escrow because he had to find a property to move into. And the buyer signed it, seller signed it, everybody signed it. It's just when the escrow opened, the seller never submitted that to escrow to become part of the amended escrow instruction. So at the end, when buyer was asking for his 90 days, the listing agent was threatening that the buyer is going to sue you if you don't close now. He said, but I had asked you for 90 days and here's a document. And the listing agent was threatening the seller that if you don't close, you're going to get sued. So the seller got scared and went ahead with the transaction. But I was the witness. I had seen the documents, but I didn't know what I had to do as just a bystander. Do I have any responsibility?
Okay, so if I understand the question, this is on a rent back, or just
No. The
escrow?
seller just asked for 90 days escrow to find a up leg to move into.
Got it. Okay. All right. So yeah, those particular scenarios, you definitely want to disclose that and let escrow know so they can put it as either an amendment to the agreement. If this was a transaction that was done outside of escrow, but was signed by all parties, then therefore you have some type of paper trail. Now, the question here is, why was this not given to escrow in a timely fashion?
We asked escrow that question. He said, go and ask the listing agent.
Okay. All right. Those are very unique situations. In my personal belief, in my personal opinion, this could have been easily resolved if we would have been proactive in the very beginning. Something happened, transpired, that the agents did not communicate well in that perspective, that escrow was not aware. So, you know, who are you here to blame? Well, you can see it from two different perspectives, Farah. One, you can see it from the buyer and the buyer's agents. Well, we were asking for it, or the seller was asking for it. And we disagree. We wanted to close in 30 days. Now the dispute happens is what you can do is stop from escrow closing, okay? And being diligent, if you represent the buyer, then you need to speak with the lender and say, hey, we have a situation. Or if the seller is the one that is asking for it, then escrow as a neutral party will get instructions from either or, meaning from the buyer or from the seller. So if the seller needed that and was never provided, then they need to reach escrow and say, hey, you know what, we need to prolong the escrow. Now escrow is in the know abouts, and then escrow will send out a document to the buyer, letting the buyer not know that, hey, we're
Refused to
extending
do that.
escrow.
Escrow refused to do that because she was protecting the listing agent.
Well, that again, I don't know what transpired, but escrow should not be protecting. Escrow is a neutral party. Escrow does not side with anyone, regardless if the escrow was provided from the seller and the listing agent. Remember, escrow is neutral. So in that situation, what I would encourage is if you're not getting anything from escrow, then you need to step it up and speak with the escrow manager or someone above the escrow officer. And
She was
bring-
the
What's that?
escrow officer.
She was what?
She was escrow officer.
Yeah, and as I mentioned, I would definitely bring it up to someone higher than her. Bring it up to the manager, the office manager, general manager, someone above her, and I would have been, heavily involved in that conversation. Now, also in the big picture, folks, and this is something that is going to be part of this presentation, you need to bring your office manager and your broker involved as well, okay? Any type of scenario that is going in a not so good direction, bring the broker involved. Reach out to
Listing
your
agent
broker.
was the broker.
Okay. So you as the buyer's agent would have to bring in your broker, okay? And the broker should be stepping in and having those conversations directly with the listing agent and also the broker if there was anyone above the broker. Or if it's the broker of a company, okay, like a Keller Williams as an example, bring it up to the broker of record. If it's an independent company and she or he is the owner of the company, then unfortunately, it's going to be a very unique situation that they're the boss. You just got to continue pressing upon them the importance of it because this can ultimately lead to a potential liability. And if you're not getting any results, then you, as the agent, need to bring your broker involved and let the broker help navigate those scenarios and situations.
Can you report that to the board?
Well, it depends on the circumstances, Farah. Yeah, can you file complaint against unethical practice? Yes, yes, you can. You can bring it to the board. Obviously, you have to have a compelling paper trail and a chronicle order of events that transpired that led to this issue that now it's going sideways. And yes, you can file a complaint against the agent or the broker itself. Okay. Good questions. Good questions. Thank you very much. All right, let's continue. So contract terms. So part of the issues of avoiding any problems after the deal closes or even before the deal closes is being proactive. Okay. What does proactive mean? Being engaged before something happens, it's like being a defensive driver, right? If you have your hands on the steering wheel 9-5 and you're not engaged in your cell phone, not texting, not calling, not looking at social media while you're driving, guess what? A lot of people do. But if you're engaged as a defensive driver, you can avoid a potential accident, okay? Because you are 2 steps ahead of the game. You can see what's out there. Well, real estate is no different. If you are defensive in your position, knowing if there's something that just doesn't feel right, doesn't look right, bring the right people involved so they can help you navigate this. Don't wait until the problem is there and the chaos is there, be proactive. If you see any type of red flags, bring the right people involved. Don't think that you need to handle this by yourself. You don't. Okay. Now, the other approach is once you do more and more transactions, you're going to understand the dynamics and how to have those conversations that will lead to a win-win. Because at the end of the day, we all want to move forward. As long as the buyer wants the property and the seller wants to sell the property, we as agents should not interfere with that process, because one, you're interfering with your own commission. Two, you're interfering with your own production. Three, you're interfering with the buyer and seller's transaction. They're the ones that want to buy and sell, not you. So be very cautious and very careful in how you approach. Don't be that agent that you feel that you have to take control of everything, because that will put you in a liability scenario. Okay, so requests for repairs and contingency removals are very important as part of the proactive approach. The RR, buyer release seller from any claims regarding disclosure condition, in the CR, buyer is deemed to have completed all and any and all investigations related to remove contingency. So here's the thing that you can articulate your conversations if a buyer comes back and says, Simon, I bought a junk property. Simon, the issue of the plumbing, electrical, foundation, roof, whatever the case may be, and it happens to fall after close of escrow, then your conversations to lead the buyer to understand, one, is that, it's pride of ownership. Now, as a new homeowner, you're going to take full responsibility of your home, just like your vehicle. Okay. If you're not a mechanic, you're going to have to get a mechanic to service your vehicle. Now, if you're handy and you can do a lot of the maintenance in your vehicle, then good for you. You save yourself a lot of money. That's why there's Home Depot. That's why there's Lowe's. Okay. For the weekend warrior that loves to do handiwork. Now, going back to the pride of ownership, absolutely. So the conversation you're having with the buyer is, I understand your concern. I understand your frustration. Let me look into it a little bit deeper and see if we can come to a resolution. Remember, you are stepping in to help navigate the buyer's frustration and maybe anger, okay? Your job is not to get too entangled in that, because this is a done transaction. So I want you to understand and separate both of them from getting yourself in a potential lawsuit, because I've seen it firsthand, folks. I've seen it where the buyer agent or the listing agent gets so involved in it now, because there's no resolution, either the buyer or the seller are suing. And now they're going to bring you because they're going to say, well, Simon told me to. Simon said to do this. Okay. And that's what causes liability in potential claims. All right. So facilitating communication. So to navigate this, if it arises and comes to you, offer to transmit information. And here's how you can do first and foremost, let me pull the file and look at it. I know it's been a month or so, and I don't recall too much of what transpired, but let me pull the file. Let me look into it a little deeper. Let me see what was disclosed from the seller, and then I'll get back to you as soon as possible. Okay. Then once you research and you look at the file and all the documentations, it'll give you a good understanding and a perspective of what transpired. Well, the seller disclosed that they were having some plumbing issues, and the buyer acknowledged, understood, and signed off on it. So that in itself puts the buyer in a position of taking ownership and responsibility. So now you can have that conversation with them. Number two, you do not guarantee any results, okay? I guarantee that I can fix this. I guarantee I can uh, communicate and resolve this. Never, 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 never guarantee. All you can do is let me make some calls and see what I can do, and leave it at that. Don't go into, I promise it'll be taken care of. I guarantee this will be taken care of, because now you're putting yourself in that position. And now they can say, well, you promised, Simon, you guaranteed me. And guess what? The buyers will hold you accountable to that. So be very, very, very careful. If you're a dual agent, you do not take sides. And that's a very sensitive situation, because if you represent the seller, you represent the buyer, you can be in a potential unique situation. You do not take sides. Even if you represent, and maybe it's family, and you represented the family members on selling their homes, and that can happen. You do not take sides just because they're family. You play the neutral individual. I will get this information, I will pass that information, but do not side. Because once you side, the other agent can, or excuse me, the other, the principal or the consumer can come back and say, well, I don't think you represented us to the best of your ability, okay? And the moment that is said to you, watch out, be very, very careful. You are legally obligated to be neutral. Okay, yeah, as I mentioned, you are the neutral party. You're just trying to put the puzzle together to find an end solution, but you are not heavily involved. You can transmit, you can communicate, but you're not going to go in there and say, well, it's your fault, listing agent, it's your fault, seller. You need to fix this, okay? That is not your responsibility. If a situation arises due to non-disclosure, all you can do to protect yourself and your buyer is, I'm really sorry that you're dealing with this. The best thing that I recommend is maybe talk to an attorney and advise you on what avenue you should approach this, what remedy that you can approach it. An attorney may be able to draft a complaint letter sent out to the listing agent, and that'll start the momentum of at least communication. I'm not an attorney. I cannot give you legal advice, but I can definitely recommend at least 3 attorneys that you can inquire and get a consultation, and leave it at that, okay? Because you don't want to entangle yourself in that situation. Elevate involving your office manager or broker early. Absolutely, folks. Okay. All of you on the call, absolutely. If you are involved in a potential situation that may cause a complaint, bring the right people into this. Let your office be aware. One, because if it gets escalated to a potential claim, you need to get the E&O insurance, your errors and omissions involved. You don't want it to go that far, and now the insurance will decline your request because you did not bring them up to speed immediately. Don't be that warrior last minute. Hey, I just got a summons for a complaint lawsuit, when you knew about this months and months in advance, okay? As soon as something is a red flag and there's an issue, bring it to the right people. Bring it to your broker or office manager. Manage the risk by getting a neutral help and ideas to resolve the dispute. Yeah, there's so many people that have dealt with different scenarios and situations. Maybe just talking to the right people. Hey, Simon, I have this situation. Oh yeah, you know what? This ended up happening to one of this other agent. This is what transpired. And maybe it's a light and an idea that, oh, I didn't even think about that. Now you can use that as a conversation to de-escalate the situation and probably save this from escalating to something bigger and major. Negotiating first and then, okay? Small claims up to $10,000. Mediation, which is the California Real Estate Mediation Center for Consumers. If no settlement, then arbitration if initialed by both party in a contract or litigation. So these are some of the dispute resolutions and alternatives that you can suggest to your client, because it's all based on the contract. What the contract states is you must mediate, and then you must arbitrate if you cannot come to any resolution from a mediation case. And that's, I believe, in paragraph 33, 34 of the RPA that says about resolutions of what you need to do as a consumer, buyer, consumer, seller's consumer. And again, they can mediate this, and find an avenue of solution. If it's something of major, such as a disclosure that was not provided from the seller to the buyer, they may have claim, they may have damages, and they may have where the seller will have to come and fix the problem or pay the buyer monetary damages. Now, again, the proactive agent, you want to avoid the deal ever closing. So if during escrow, have the consultation with the buyer and explain to the buyer and say, look, here's what we can do. We can stop from closing and allowing the extension of escrow to close, but there's still no guarantee, no promise from the seller not pressing us to close. But if there is a compelling position, you have the right to hold the process from closing because there's a situation that occurred. Maybe there's not a meeting of the mind between the buyer and the seller, and the buyer wants an answer before closing because now the liability may fall upon the seller because the seller failed to not provide adequate information or adequate disclosures regarding a particular situation that could have been easily resolved if there was communications. Okay, so mediation, arbitration, and then ultimately, if none of those two items are effective, then you can escalate it and ultimately get attorneys involved and let the attorneys deal with it. Now, everything that I just mentioned, mediation, arbitration, attorneys are at a cost. It's going to cost money. But how, as an agent, can you be proactive? Well, communication is the cure to a lot of the problems. Maybe the seller is compelled and the seller might have slipped their mind and realized, oh, shoot, I totally forgot about that situation. No problem. Let the buyer and the buyer's agent know we will handle that. And there you go. Problem solved. And now you just resolve something that could have been easily escalated to a huge thing because you were proactive and made those conversations. You reached out to the agent. All right, recommended client consult an attorney. Absolutely, as I mentioned, real estate license should never speculate on who is right or who is wrong, right? Or who will win or lose in court. You don't know. You're not a trial attorney. You don't know the dynamics of it. If you're not a practicing attorney, you should not be giving any type of legal advice. Provide referrals, as I mentioned, names, but it's always best to give at least what? 3 options. Leave the choice up to the client. Let the client choose, not you. Oh, I recommend this agent. He is phenomenal. He's dealt with a lot of my clients. Maybe that attorney is not a good fit for your client. Maybe it was for past clients, but maybe not for this one. And they utilize this attorney and the attorney does not have good results. Guess what the consumer is going to do? They're going to point the finger. Well, Simon, you refer this attorney. Never, never, never do that. Always recommend a minimum of 3 attorneys. And sometimes it's not even good to recommend attorneys. The only attorneys I have is our in-house attorney, but they are attorneys that represent us. Unfortunately, I do not know any local attorney. You can Google, or ask word of mouth for any potential attorneys in the South Bay area. Now, you can also provide, 3 referrals. If you have 3 solid referral attorneys that know real estate disputes, then you let the consumer provide that information and let the consumer choose what direction they want. Consultation, maybe the attorney gives them a good consultation that they feel compelled and want to use that particular attorney, but it's not something that you force the consumer to use. It was a recommendation. And then additional resources, quick guides, mediation versus arbitration, mediation for consumers, transfer disclosure state law overview. These are all part of your legal Q&A, part of the California Association of Realtors. So take full advantage of everything that's on here that will help you be a more agent that understands your position as your agent. Okay, that's your job. You're here to just sell. You're here to connect the buyer and the seller and close. And that's where you can avoid any type of situation or opportunity for you to be involved in a claim or a lawsuit. So these are some stuff that you can pull up from the California Association of Realtors. For example, arbitration for consumer. If you're a member of the association, it should take you to all these guides that you can utilize. What is arbitration? What type of disputes can be resolved by arbitration? So again, just giving you the big picture, folks, and understanding your position of where you stand when it comes to these post-closing situations, because I can promise you it will happen to you if you're doing business out there, is being proactive, engaged, and then ultimately understanding your position. So I'm going to leave it up for any questions. I think Zoe had a question here. Does the seller still have to give disclosures when selling as is? The answer is yes. That is correct, Zoe. All properties sold in as is condition must still provide the consumer known material facts and disclosures. What you're doing is protecting the buyer, you're protecting the seller and protecting the buyer from a potential claim in the future. So yes, even though it's embedded in bold in the RPA that all properties sold in as is condition, you still must provide disclosures to the consumer, okay? Well, then what's the whole purpose of that clause, sold as is? Well, what the clause basically states is that the seller will not do any repairs. What you see is what you get. If you want it, it's yours. If you don't want it, you don't have to buy. We're not going to repair anything. We're not going to replace anything. We are not going to give you any credit. And by all means, for sure, we are not going to reduce the price of the home, which part of the contract allows you to do those part of the request of repair. But I'm just giving you the general synopsis of this position, folks, is to understand that all property is sold in as is condition. Okay. Any other questions before we close it? Oh gosh, no questions. All right. I guess I did my job efficiently, right? All right. If there's no additional questions, I appreciate each and every one of you. Thank you for hanging in there. And I do definitely respect your time. And I apologize for going 11 minutes off schedule, but I think it's a very important to understand your position, that again, you are not here to give any legal advice, taxation. Your job is just to put a buyer and a seller into escrow, close, and get paid. That's where you want to be, not the headaches. Let the people that deal with that situation, not you. Just go out there, put buyers and sellers in escrow, and get paid. All right. All right, folks, thanks again. Enjoy the rest of your afternoon. Reach out to your brokers and your team leaders if you have any additional questions. All right. Talk to you soon. Bye-bye.
Thank you, Simon.
Thank you, Simon.
Thank you.
Thank you, Simon.
Bye.
Thank you. Thank you. Thank you. Take care.
You.